Before anyone on your legal team opens Word, your AI privacy has already been decided. By default conditions, retention windows, and branch policies you didn't negotiate. This isn't how to use Copilot. This is how to buy, adopt, and govern AI so your attorney-client privilege doesn't fail on paper. In the next few minutes, I'll give you the contract kit that locks in privacy in writing, tests to run before you go live, a no-code access shield, and a risk-based decision tree that you can use with any vendor. I'm Rok, founder of MPL Legal Tech Advisors. We assess AI risk and opportunities for legal teams, pick the right use cases, and deliver a governed roadmap. So strategy turns into adoption. Now, most legal teams assume that enterprise license equals privacy secured, but it doesn't. Training exclusions, review bucket retentions, and cross-border data flows are buried in sub-policies. And that's where the legal teams get blindsided. Across the big providers, consumer chat data is trained by default, and some of it is held for really long periods. Now, enterprise contracts usually exclude training data by default and also offer higher retention controls. I based my analysis and the framework in MPL Legal Tech Advisors on these two papers. Now, consumer privacy requires opt-outs and careful configuration, and sometimes isn't available at all, while paying enterprise plans gets you some protection by default. The Stanford paper especially notes a competitive race for high-quality data that incentivizes the developers of those companies to harvest user chats directly and to improve the models. So the defaults are set accordingly. And the risk really does start on paper. Vendors spread crucial details across the web of branch policies, FAQs, helper pages, and actual sub-policies. And that's making the whole data retention story really hard to reconstruct for non-technical users. So this next section is supposed to give you some actionable steps in what are the 6 clauses to put in any kind of agreement with a legal AI vendor. So the first one is the most obvious, which is no model training on your data. You must define that the provider should not include any prompts, outputs, embeddings, or any derived data to train or fine-tune models outside of your tenant's environment. Now, specify in that clause that the provider acts as a data processor under the DPA for all AI interactions. Clause number 2 is fixed retention. Chat logs and any reviewer QAs, and what do I mean by that? They retain data. Out of the chats and the prompts and the outputs, they're assembling data sets. Those data sets are used for further purposes: research, product development, training of the models. So you want those data sets, subsets, to be purged after X number of days, 30 the max. Now, you should be aware that there's disaster recovery copies on the vendor's end. You want those recovery copies to follow the same window. The rationale here is that some developers keep review buckets longer than the usual. Now, close that gap in writing. Clause number 3. No cross-product pooling, including web queries. Example, our data isn't used to train or enrich other services in the vendor's ecosystem, search, ads, consumer portals, telemetry, analytics, where AI features invoke web or search services. You know, when you use ChatGPT and you ask it something and it searches something in the background, it's not actually AI searching. It's AI making an API call to a web search service that does the search, gives out the results, but there's another service that uses your data. So where those AI features include web search or any other external services, those requests should be governed by this DPA and the same no training retention terms. The rationale here is your providers, including especially Microsoft, are blurring those boundaries between the services. If you don't believe me, Microsoft themselves on the learn.microsoft pages is specifying that they are using the data acquired by services such as MSN, Bing Search, and others to train their AI models. And that's exactly what I mean by blurring the lines between the services. Now, you gotta have your terms of service attached to how your data travels, even if it travels between the services. Number 4, freeze the branch policies. Attach a single privacy exhibit that lists every sub-policy in scope. No unilateral changes. Updates should require prior notice and your written consent. You'd be surprised how many updates are pushed in an incognito way. The next time when you approve terms and conditions changes in your AI vendor, please read it. And again, those policies are often spread across different FAQ and sub-pages and sub-policies, so make them binding and stable. Number 5, jurisdiction and audit. Make sure in this clause you specify that the data residency should be as required based on your professional obligations. There should be a cross-border boundary where applicable. Make sure there's an independent annual audit of AI data flows. The data flows are important. Where does the data actually physically travel Not just to, but through what. You want to have the right to examine access and the interaction logs on request. The last clause, you want breach cooperation and communication from the vendor and set the timers for that. For example, you want a 24-hour notice, you want a named security contact, you want immediate log preservation, and you want a joint client notification plan aligned to your regulatory obligations. If you need a second pair of eyes on this, that's exactly what we help legal teams with at MPL Legal Tech Advisors. Book a consultation call with me below. Before you go live with the tool, you want to test it out. So here's your 5 checks to do just that. First one is account segregation. A personal account must not reach your corpus. Only the firm tenant can. This is where you validate that identity-based access boundaries are actually enforced and not just promised in marketing. The second one is over-permission surfacing. Now what's that? Create a shouldn't see folder. Put some documents in there. Now, set the permissions so your AI assistant shouldn't be able to surface the documents in that folder. Now, this test proves whether the retrieval layer, because every assistant needs some sort of document to answer based upon. So the assistant will always retrieve some documents before answering. Now, there are some sensitive documents. That's how you want to make sure that the retrieval layer already has that access boundary. And this is concrete control against the chatbots and AI assistants leaking content because the default configurations were never tightened or there's still something in the back that's pulling the data. The next check you want to do is whether it refuses prompt injections. Seed your document with hidden instructions. Put them in metadata. Send that document to your assistant and let's see whether your assistant will act based upon those hidden instructions. Don't rely on your vendor claims on this. You can do that very easy. Have your own set of criteria, your own set of hidden instructions, and if the vendor passes them, then they are meeting your security standards. And this is a very simple way to test security and to enforce it without having to invest a lot of money into building your own middle layer of software that does that for you. The next check is the citation truth. So sample outputs must be verifiable by the sources, and the tool should provide those sources. Otherwise, you're gonna just spend a lot of time checking on the outputs. We all know that generative AI can produce very confident but completely fabricated outputs. Because it doesn't give us the truth, because it doesn't know the truth. It has a lot of data and it predicts what is the best next word based on what I'm seeing right now. Now, this doesn't mean that you shouldn't use AI, but being aware of this empowers you to know why you should check every single output before it leaves the firm. So use it for drafting, not for the work product. And the next one is the telemetry and rollback. That's not gonna make your vendors happy, but I would advise to ask where your logs are retained and check them. Let's see how they're redacting that data. Based on the experiences I had working for an enterprise, we had very strict regulations on how the logs should be preserved. Of course, they should be preserved, but the malicious actor could extract the logs. And if the logs have some sensitive or personally identifiable information, those logs are your huge liability. So it's a bit of an art how to retain the logs, so to give you full visibility over what happened within the system, who accessed it, who did what when, and still adhering to all the regulations. And as the telemetry, I would require from the vendor to disclose who are the third parties that they're sending the data to, and how does the data look that they're sending to that third party. Because if you don't know that, you have no way of knowing what are all the points in the chain where your data could be theoretically mishandled. Now, if your vendor can't pass that, I would say then they're not ready to handle your client data. Now, you don't have to buy software, but you do have to assemble your simple privacy shield with the controls that are available to you now and that you already understand. Look at it as a pipeline of steps you're going to do. And the first step in the pipeline is the pre-flight check, the policy-first approach. So scan your prompts for all the sensitive information, all the personally identifiable information, health data, biometric data. And if they redact it, change it with tokens. And you could automate this and you can tie this to your sensitivity labels, for example, Microsoft Purview. So your Copilot, for example, can follow your labeling rules. And you do have tools for that. For example, DLP tools with prompt inspection. Second step is edge redaction or tokenization. You want to auto-replace the sensitive strings with format-preserving placeholders so context survives. You have tools for that, for PII redaction and tokenization. Step number 3 is outbound filter. Before anything leaves your firm or leaves your assistant, you want to auto-scan the outputs for secrets and unverified citations. You want to require human review above the threshold. Now, tools for that are AI gateways, LLM firewalls, prompt security layers, or tenant admin toggles. After review, you can reinsert the originals on your site. And you can add a routing rule. For example, if the prompt is sensitive, route it to a small local AI model that you're running on your own infrastructure. That's for the flows that must avoid the internet. And then keep the richer features for low-risk labeled tasks, and you can use the public AI for that. Think of this as a pipeline. User, pre-flight check, AI model that routes to either private or public solution. Then you have an outbound filter that checks what comes back, and then you have a human reviewer. Now, the essential artifacts that you would need in your firm or in your legal team are the following. You need an AI usage policy, who can use what, where, which task, explicitly ban the workplace harm use cases. For example, no AI judgments about the employee performance, attitude, or personality. Tie the usage to your labeling rules and practice group guardrails. You need a changelog and your AI tool re-evaluation cadence. You need to track your vendor or AI model updates and rerun your pre-flight or pre-production test battery after each meaningful change. Because the capability updates still need to adhere to your security, note that the capability updates don't alter your security settings in those platforms, but they can break your workflows or prompts. The next artifact that you need is your duty to supervise. You need to have training completions, spot checks, and second review sign-offs for any external facing output. And you need to keep the artifacts, checklists, red lines per matter. You need quarterly shadow IT checks. You need to document any chatbot use with client data and the remediation, revoking tokens, purge requests for your data, and user retraining. And you need an incident run book with names, timers, and scripts. 24-hour internal SLA, named leads, log preservation stamps, privilege safe client notice. Include the IP indemnity terms, for example, Microsoft customer copyright commitment, and the prerequisite. You used building guardrails as contracted. These 5 artifacts cut the premiums, speed the procurement, and prevent unpleasant surprises at renewals. Now, your AI vendor selection or your AI tool selection should be based on the risk and not the features. So when do you go for the consumer chatbots? You go for them when you're using them for internal notes only, and when you're using them for when there's no client data involved. Even with the opt-outs, remember, some of the cross services may not be covered by the enterprise privacy protection. So treat your chats as non-confidential. When there's some concern about the data, when you want at least some level of privacy and protection, you should go for enterprise plans. You should really look at them as an entry level. And then if you really need to process high sensitivity matters with names, social security numbers, health data, and you cannot afford losing the control of your data and not knowing who accesses it, you really only have one chance, which is self-hosting private open source large language models or private AI. And there are solutions for this today, and they're much more affordable than what you might imagine. And I'm talking full-blown hardware plus turnkey software solutions in one. And those open source models that have open weights, they allow you to run the inference completely locally. So let's cut the jargon. What does that mean? There's no third party. It's a much tighter retention and data protection and data control. And it's a much more simple privilege posture. Now this is your buying logic. Take it with you to any legal AI vendor meeting. Quick recap. Log privacy in contract, prove it with a pre-production test, enforce a no-code access shield, keep the GC artifacts, and pick your legal AI tools with a risk-based decision tree. If the legal AI vendor can't pass your sequence, they shouldn't touch your client's data. Models and legal AI tools change weekly. Your obligations don't. If you need a sanity check on the contracts, default configurations, and the data retention, that's exactly what we help with at MPL Legal Tech Advisors. Book a consultation, you'll find the link below. If this helped, share it with a partner or a GC wrestling with AI procurement. Thanks for watching and see you in the next one.